Aloha. This is my CHATIT analysis of Chapter 19 Reform. Before we get to the analysis, I want to make sure that we have a working knowledge of what Chapter 19 is. It's the ruling document that provides students with expectations, rules, policies, and guidelines for administrators for when a student's behavior violates those policies. It also protects students' rights like due process. Why is this important? If Chapter 19 is the ruling document, then it is responsible for the disproportionality that we see in our schools in Hawaii, in which 35% of the student population is Native Hawaiian Pacific Islander. But that same population makes up 58% of the suspensions. As we see in the next set of statistics, there is a mirroring of those percentages. The juvenile justice system is made up of 41% Native Hawaiian people, followed by an adult incarceration of 39% Native Hawaiian people. The CHATIT analysis revealed different areas of Chapter 19 where it mirrors the US law code and several other systems. What I think is that Chapter 19, mirroring the US law code, of course, it's then going to mirror the results. So if we change Chapter 19, we should be able to expect a change in those results. So let's talk about Chapter 19. It's undergone many amendments as recently as 2019, but its initiation was in 1982 with its adoption, which is where this analysis is going to be taking place. Before Chapter 19, we had Rule 21. This was a document that was an administrative rules that gave principals a lot of leeway in what they could expect from students as well as what they could consequence students with. While it's not available digitally, we can find excerpts from statutes as well as court cases, which you can see there in the quotes. Um, the court case that really reveals a lot about Rule 21 is in Bobolin versus Hawaii Board of Education, in which Bobolin sues BOE for a violation of his students' 13th Amendment, stating that his students were treated as slaves when they were suspended for not performing their cafeteria duties. The court says that it's within the rights according to Rule 21 to do that because that activity was not economic based but education based. The federal driver that pushes the U.S. really into adopting um, new uh, school codes, disciplinary codes, was Goss versus Lopez, in which Goss argues that his students' 14th Amendment, which is due process, was violated. The court agrees and mandates that schools include due process in their disciplinary code. Hawaii responds with something called the Due Process Handbook in 1980. But in 1982, the Board of Ed determined that that wasn't good enough, that it wasn't going to provide enough cover, essentially, if a lawsuit were to happen, which rightfully so. But the DOE then determined to create the Chapter 19 that we see today in a way that reflected um, U.S. penal systems as well as the U.S. justice system. You can see that in one of the first court cases after Chapter 19, which was Makanui versus DOE in 1986. In that, the court ruled that a student could be suspended from a team without due process, without a consideration of their rights, simply because this team was a privilege, not a right, which is a common theme that you see in uh, the 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 U.S. justice system. So let's take a look now at the analysis. The goal, as stated by Chapter 19, was to define disciplinary actions that you see there, and then to create proactive systems of support, and then to safeguard students' rights. Some mediating artifacts would be the U.S. Constitution. When we see things like from court cases that are pushing changes in the school code, um, like 13th Amendment due process, 14th Amendment for due process. Subjects, we have administrators, students, and families. Administrators, the Chapter 19 provides them with the procedures and expectations. And then for students and families, they're expected to read and understand these things. Rules, we see the Rule 21 prior to Chapter 19. We also see due process in this first adoption. Community, we look at schools who perpetuate that quasi legal system. We look at the surrounding communities, so that families and neighborhoods who have to use the language from Chapter 19 to grieve and complain. We see staff who interpret interpretations of those Chapter 19 rules, creating mandatory minimums in some cases. For institutions, we are looking at the US Constitution with the 13th Amendment, student rights, and due process. We are looking at the US legal system because Chapter 19 operates or allows proceedings to look a lot like a court system. And then we see the penal system, so consequences that can be applied to different violations. We look at the division of labor, which is particularly interesting to me. The Board of Ed interprets US law or state law and then approves policies according to those interpretations. Families and staff, they act as almost informants when they're reporting those violations. And then we have administrators who hold a lot of the power when it comes to what happens to those students. So they interpret the interpretations, they implement, and then they encapsulate the entire penal system. Then they rely heavily on the rules from Chapter 19. Outcomes, what we see in the outcomes, what are a school policy that reflects our criminal justice system. I think this creates a culture of compliance, which is that we have this system that keeps us from legal action because it reflects the legal system. We see that throughout the rest of Chapter 19 reforms, all of which are compliance based. So, what now? Chapter 19 did not have to look like how it looked. It was just the easiest way to avoid further legal action. So, Chapter 19 could lean in and distribute the division of labor a little bit more. And that could bring about a little bit more of democracy into it. It could innovate and combining those students' right with an even more democratic system of inclusion and transparency. Or it could abolish it, start over, literally from ground zero, and create a disciplinary system that both addresses student rights, but also the student in their entirety.